Life is unpredictable, especially after the pandemic. Have you ever wondered what will happen to your dependents if at all any unfortunate event happens to you?
Stop wondering and make a will to secure the future of your loved ones. Watch this video till the very end to find out how to make legally a valid will. Hi everyone, I am Prarthana from Clear. It is India's largest tax and financial services platform. Clear serves more than 2000 large enterprises. Subscribe to our channel to know more about business and taxation concepts. So, what is a will? A will is a legal document written by a person who is called the testator. Thus, when you write a will, you will be the testator of your will. A will states regarding the distribution of the testator's assets and possessions after his or her death. It also states about the custody of minor dependents and management of accounts and interests. A will becomes effective only after your death. It informs your loved ones about your decision on how your property and assets are to be distributed after your death. Writing your will ensures that your wish regarding the disposal of your assets and property is followed after your death, thus securing the future of your dependents or loved ones. There is no specific format or form prescribed under the law to write a will. You can write a will even in your regional language. You need not write your will on a stamped paper. It will be valid even when handwritten on plain paper or typed on a document. However, your will must disclose your intention of distributing your property after your death. Hence, a will needs to contain the following details.
Firstly, details of the testator, such as full name, address, and date on which the will is written. Details regarding the appointment of an executor who will ensure that your property and assets are distributed as per your wishes written in the will. Details of the property that you own, such as the full address and schedule of the property. However, please note that you can write a will only after those properties which you own from your self earnings. Details of the assets that you own, such as description of jewelry, car, books, electronic devices, etc. You can mention every asset you own, including movable and immovable properties. Details of the beneficiaries who will inherit your property or assets. You need to mention which property will go to which beneficiary, that is, the ratio of the distribution of assets. A beneficiary can be your children, parents, spouse, or even trust or charitable institution. When you are responsible for taking care of a minor, including your own child, you can mention who should care for them. You can even mention the minor's shared treatment till they are legally entitled to inherit it. Sometimes when you write a will, you may not cover everything you own. Thus, you can add a residual clause for the distribution of your remaining assets not mentioned in the will, so that it is clear for your beneficiaries how to divide your assets that are not mentioned.
A will must comply with certain requirements for it to be legally valid. If it is not valid as per the court, it is as good as dying without a will. The requirements of a will are:
You must be of legal age to make a will. Most states consider 18 years of age as legal. You must be of sound mind, which means you should be capable of understanding that you are making a will and its effects after your death. When you are not suffering from any mental incapacities, you are considered of sound mind. You need to have an intention of making a will. You must make a will voluntarily. If the will is made under pressure or under someone's influence, it will not be valid. There has to be disposal of property among family, friends, or beneficiaries in your will. However, you can revoke or alter your will if required during your lifetime. For a will to be valid, you must sign each page of the will and mention the date. Two witnesses must also sign it in your presence.
are the requirements of a will making sense? If it is, write clear in the comment section below. Do let us know what topics you would want us to cover in our future videos. The sole purpose of appointing an executor is to execute a will. The executor will be given the right to ensure that all the contents of your will be executed correctly. An executor is responsible for administrating and distributing your estate after your death as per the will. When no executor is appointed in the will, the legal heirs can appoint an administrator to execute the will and carry out the executor's responsibilities. A probate of a will is mandatory in a few states in India. In such states where the probate is mandatory, the executor or legal heirs must apply for probate of will to the district court. A probate of a will is the legal certification of genuineness of the will. In India, the Indian Succession Act 1925 governs a will. It is not mandatory to register the will. However, it is better to get it registered with the sub-registrar office of your area if it involves immovable property to prevent the will from being challenged after your death by any person. When a person dies without making a valid will, then it is termed as intestate. When people die intestate, his or her assets and properties will be distributed according to the personal laws. For example, a Hindu is governed by the Hindu Succession Act 1956 in the matters of inheritance. Thus, if a Hindu male passes away without leaving a will, his mother, wife, and children, including the daughters, share the assets equally. If a Hindu female passes away without making a will, her husband and children will inherit her assets equally. Mohammedan law governs Muslims in India. Thus, when a Muslim male dies, at least 2/3 of his property must be divided among family members. However, his children do not get an equal share. According to the Mohammedan law, the sons get twice the share of the daughters. The assets of Christians and Parsis who pass away without making a will are distributed as per the Indian Succession Act 1925. So folks, that is it for today. I hope you understood the requirements of a will. If you have any doubts regarding a will, please leave a comment in the comment section below regarding your queries. For queries related to business or finance, you can even contact our experts by clicking on the chat link provided in the description box below. Also, don't forget to subscribe to our channel for more finance related updates and informative videos, and stay tuned for more updates. Thank you so much for watching. Take care.